Hello everyone and welcome. We're just admitting a few more people here today. We've got lots of you joining us today. We've got 65 already in. 74, lots of people joining us. I'm just going to give it a few more seconds just for most people to join us, and then we'll start. Okay, right. We have got about 80 of you in now, so I'm going to keep hitting admit, and then we are going to start. So welcome everyone today. Thank you very, very much for joining us on this really important topic, one which we don't really talk about enough in the UK. So in the UK, we have been very, very strong, I would suggest, recently in training people on mental health issues at work. So particularly things like mental health first aid, all of those, and general mental health training for managers, for individuals to understand themselves better. We've been very strong on that. When it comes to a global level, I think that we would say that we were pretty good. However, where we are not so good, in my opinion, is in seeking out what causes stress in the workplace to start with. So we're good at training people to look after themselves and not quite so good at actually looking at what is causing stress in the first place. Today, we are going to be looking with two preeminent experts, and I'm really delighted to have both of them here today. Professor Sarah Waters is the Professor of French Studies at Leeds University. Now, why a Professor of French Studies and why this subject in particular? Well, you will learn, if you don't know already, that in the French system, there is a very different way of dealing with suicide at work. And Sarah is going to explain all of that to us and talk about some of the amendments that really we think should be made to the law in the UK potentially. We also have Mary Lawrence. So Mary is a preeminent legal expert in the health and safety arena, and she's going to talk about some of the cases which have come to fore in the UK, and particularly some of the civil claims as well. So we're going to go to Sarah first. And I'm facilitating. Now, at any point in time, please pop a question or a comment in the chat box. There are a lot of you here, but we want this to be interactive as far as possible. They may come to you and answer you in the chat box, or we may take that as a question later on. So, but please do pop your questions in, but I'm going to go straight from Sarah to Mary, and then we're going to deal with the questions at the end. So hopefully some of those should be answered throughout the presentation anyway. So Sarah, you're going to say next slide, please, to me when you're ready, if for each time, aren't you? Because I'm going to be your dolly dealer. So I'm going to move on now straight away to introduce Professor Sarah Waters. And thank you everyone for joining us today.
Okay, thank you very much, Heather. Thank you for the introduction. I'm really delighted to be here today and to talk to you about this complex and difficult subject. Just a few words of background to explain how I came to this subject, because as Heather said, you might be wondering why on earth a professor of French studies is here today talking to you about work-related suicide. For many years, my research has focused on labour studies in France, on the French workplace. So the workplace as a window onto wider French society, cultural values. You know, work can tell us everything about a society. So for many years, I've been interested in work. Then in the summer of 2009, the French media began reporting about a wave of suicides that were taking place in France Telecom, the French telecom giant. Between February 2008 and October 2011, 69 employees at this company took their own lives. And like many people, I was horrified by this news. And I think I was also fascinated because this seemed to go against everything that I had learned about work and about the workplace. Work is a space that brings the individual into society, that gives you a sense of identity, it gives you a foothold in the world, it gives you a place in society. And how could this be happening? How could it be that someone's work had got so bad, and that they had become so desperate that they would take the step of taking their own lives? So I was fascinated and horrified equally by what was going on. I then went on to undertake a research project on work-related suicides in France, which resulted in this book in 2020. And I studied over 60 suicide cases across 3 large French companies. My approach to the subject was to look at the letters written by suicidal individuals, to try to get an insight into what was going on by looking very closely at the words and thoughts of those who had made the decision to take their own lives because of work, because of working conditions, because of their experiences in the workplace. So if you want to go to the next slide, please, Heather. I then became involved in a campaign led by the Hazards group in the UK. Hazards is a trade union group. For many years, they have been campaigning to try to get the health and safety executive to recognise work-related suicides, to record work-related suicides, to investigate them, to take them seriously. So this is what you see in front of you is an e-postcard which Hazards have, which is addressed to the chief executive of the HSE and is calling on the HSE to record work-related suicides as the first step in investigating and preventing them. So the idea that justice and numbers go together, that if you don't count something, then it isn't worth counting. You can't hold people to account, or you can't hold something to account. The first step is to record work-related suicides.
I'm sorry, Sarah, I hit the mute button by accident. I was trying to mute somebody else. Apologies.
That's no problem. Okay. Mary will talk in more detail about this, but the UK regulatory context is very different to the one that exists in France. In France, if a suicide takes place in the workplace, it is automatically investigated and presumed to be work-related unless proven otherwise. And so I was trying to support the campaign using my knowledge of the French context to support this campaign to have work-related suicides counted and more direct action on this issue in the UK. The next slide, please, Heather. So just some background on work and suicide in the UK. We know that employment can be a protective factor against suicide. Nonetheless, the highest suicide rates take place amongst working age adults. The highest suicide rates in the UK are for working age men between the ages of 40 and 50. We also know that suicide rates in the UK are on the rise since 2017. In the absence of official data, Hazards has estimated that there are 650 work-related suicides in the UK every year. That's over 54 per month. We know from data collected by the Office for National Statistics that certain occupations have higher suicide rates. Construction workers have the highest suicide rates for men. care workers have the highest suicide rates for women. Suicide is a gendered phenomenon. This is particularly the case in work-related suicide, where we find the highest rates both amongst male-dominated occupations such as construction and also female-dominated occupations such as social care. There's growing evidence in international research of the links between suicide and psychosocial conditions of work. Just to give you one example from one of the studies cited here, the Miller 2018 study, which was a review of 22 independent studies, and concluded results of this review suggest that exposure to various psychosocial job stressors was associated with elevated risk of suicide ideation, attempts, and death. Next slide, please. So just some information on the international context. The trends in the UK are comparable to what is happening elsewhere in the world, where suicide rates are highest within the working age, amongst working age adults. In the United States, data on work-related suicide has been gathered centrally since 1992. We know that suicide rates, the suicide rate within the working population has increased by 40% over the past 2 decades. Work-related suicides specifically have increased since 2007, while work-related deaths have decreased. So work-related suicides have increased, work-related deaths have gone down. In Japan, where this is considered to be a major public health issue, the government passed a law in 2014 which requires it to take preventative measures on work-related suicide and other forms of work-related death. France has become very active in recent years on this issue, and a government report from last year estimated that 10% of all suicides nationally have factors of work-related causality. Next slide, please. So just to report, this is a small-scale study that we carried out last year. And this was a study, an in-depth qualitative study of 12 UK cases of work-related suicide. In all 12 cases, work-related factors had already been identified by an official source, either by the coroner, either by the doctor, either by the employer. In each of these cases, there was extensive material evidence of work-related suicide. So we weren't coming in and judging whether they were work-related suicides or not. What we were doing was 2 things. Firstly, looking more closely at the causal factors pertaining to each of these cases. And secondly, looking at how organizations responded to each of these suicides. Was each of these suicides reported? Were they investigated? What happened in the workplace after each suicide took place? The results of our study are very similar to those of similar studies of work-related suicide in specific occupations, in that one of the key factors that we found was unmanageable workloads, which was a causal factor across half of the cases that we looked at. And you can see some of the other causal factors that we identified in our small sample. Next slide, please, Heather. I'm just taking 2 examples of cases to give you a sense of the individual suicide cases that we looked at. One of them involved a 48-year-old university lecturer who took his own life in the workplace. There was extensive documentation linked to his case, in that in the previous 3 years of staff reviews, he had reported issues with an unmanageable workload. Within the university itself where he worked, the union, the UCU, had launched a campaign on workload because it was an issue across the university. So there was, I suppose, very concrete material factors. He was in the middle of marking 418 exam papers. In the particular department where he worked, there had been an exponential rise in student numbers without an increase in staff numbers. So these are, material facts. In these, a second very sad example involved an 18-year-old apprentice mechanic. Again, evidence of very nasty bullying in the period leading up to his suicide. The bullying was reported to his line manager, both by him and by his parents. So what happened in each of these cases? In all 12 cases, we found no evidence that the HSE was involved in investigating any of them. We did follow this up with the case of the 18-year-old apprentice, where we specifically asked what the HSE had done, and they had said that the suicide had been reported to them, but they hadn't taken any follow-up action. So in these 12 cases where there is material documentation of work-related suicide, none of them were reported to the HSE. No investigations took place. They were not treated as within a health and safety framework. Other things to mention: in 4 of the cases we looked at, the employer undertook an independent investigation into the suicide. This was a very important catalyst for change within the organization. An independent investigation by the employer can be a very powerful instrument for change. What I would say is that whether an investigation takes place or not depends on the goodwill of an individual employer. There is no requirement to undertake an investigation. They only take place in a minority of cases. Prevention of future death reports were only issued in 3 of the cases that we looked at, and in only 2 cases were they addressed to the employer, even though in the inquest, the coroner identified work-related issues in 8 of the cases that we looked at. Next slide, please. So just to point to what we see is a real gap in suicide prevention. Currently, the HSE does not specifically excludes suicide from the work-related deaths that must be legally reported to them. So the wording is all deaths to workers and non-workers, with the exception of suicide, must be reported if they arise from a work-related accident, including an act of physical violence to a worker. Suicide is presumed to be non-work related. It is automatically excluded. In other countries, it is automatically included, and there are some examples there of countries where work-related suicides are recorded, where legislation has been put in place. So this has been a key element of the campaign that we have led with the HSE. And our slogan has been that work-related suicides are uncounted, therefore they do not count. This is an issue in terms of creating risks for other employees, because if suicides aren't investigated, nothing changes. But there's also an issue around justice in relation to bereaved families who, are left with not only with the death of their loved one, but no legal financial recourse following the death of a father, a son, a daughter, a wife. Just going to the last slide very briefly. And I know that Mary is going to talk more about this, so I'm not going to go into detail about this. But just to mention that there has only been one case in the UK where a company has been held liable in a case of work-related suicide. That's Core versus IBC Vehicles. The second example is more common, where no fatal accident inquiry takes place, where a bereaved family member requests it, but it is refused. And just to contrast this with what's happening in France, where in 2019, there was a very highly publicized criminal trial. For the first time, executives of a major company were given a prison sentence in relation to 31 employee suicide cases in the company. There are other companies who have also been prosecuted in relation to work-related suicides, and I've given some examples there. There are hundreds of cases that go through the civil courts. Many are successful. And I'm now going to stop and pass over to Mary. Thank you very much.
Brilliant. Thanks a lot for that, Sarah, and thanks, Heather, for moving the slides on. So I thought I'd just focus, first of all, on three core legal areas where we see that there can be legal action, whether there is or whether there's the potential for it following suicides. Particularly here, we're dealing with allegations and actions against employers. Sarah mentioned and Heather touched on talking about some cases, which we'll probably pick up in the questions then as we go through. So I'm going to talk about inquests and the risks that flow from inquests for employers, including prevention of future death reports that Sarah's mentioned. Secondly, talk about investigations and action from regulators, principally here the HSE, including criminal prosecution. And thirdly, for civil claims that can be brought by families or the estate of the deceased for personal injury arising out of suicide. If you could just move the slide on, please, Heather. So firstly, I'm going to talk about inquests, which have been mentioned quite a lot so far. Some of you may know this, some of this might be quite new to you. So in the UK, there will always have to be an inquest and ultimately an inquest hearing if there's been a suicide. The reason for that is there is legislation which tells us when an inquest has to be heard. And one of the reasons is if there has been a violent or unnatural death, and suicide will fall into that category. For those of you who are not so familiar with inquests and what they are, first of all, they're inquiry processes. And what that means is that they're supposed to be about ascertaining information. They're not supposed to be adversarial. They're not supposed to be blaming in their nature. The whole process is led by a coroner. And a coroner hears inquests and the investigation that leads up to the hearing as a result of any deaths that have happened on their geographical patch. So it's slightly different to some other types of court hearings you might be familiar with. The remit of the whole process is that the coroner has to identify by the end of it who died, when they died, where they died, and importantly, how the person came by their death. Really, inquests are very much about providing information, as Sarah touched upon, to a grieving family who just may not know a huge amount. And so the outcome should be that that sort of information has been aired. Now, although inquests are not litigious processes, they sometimes very much feel like it. Witnesses will often be called in person to give evidence, like other court hearings. Interested persons, which is a really specific term which identifies key people who might have an interest in this inquiry process, will be identified by a coroner, and they can have lawyers there in a court. Lawyers can ask questions of the witnesses, they can make legal submissions. And also in certain cases, and most of the workplace death cases that we deal with, there will be a jury. But interestingly, in a suicide case, because of the lack of reporting that we've heard a bit about and we'll touch on, there tends not to be juries in suicide cases. And what that means is it's a single coroner who hears the evidence and determines the outcome or the conclusion at the end of the hearing. In the suicide of an employee, it's really possible that an employer may be deemed to be an interested person, might raise a flag and say to the coroner they think they are. There's lots of potential grounds to say that you are an interested person. The one that's probably the most relevant here is if there's a suggestion that the employer's action or their inaction has contributed to the suicide. What's really important in an inquest for an employer to think about is these are public hearings. The press can and very often do attend. Families of the deceased are usually there. They're usually actively asking questions, often directly, sometimes through lawyers, and they're very much the focus of the hearing. The coroner is the one who decides the scope, what's to be asked, what's relevant, and therefore all sorts of issues might get aired in an inquest, whether or not an employer thinks they're relevant. There's no sort of decision at the end of an inquest. What the ultimate outcome is a conclusion. And in the case of a suicide, that might just be a simple word, suicide. So probably the most important powers of the coroner that employers need to think about in these processes are the prevention of future death process that's been touched upon. And what that means and what the coroner has to do is if they hear anything in an inquest that makes them feel that something could be done to prevent a future death to prevent a similar death in the future, they must make a report at the end of an inquest, which is public and has to be responded to. Next slide, please, Heather. Second legal area I want to talk about is the potential for there to be an investigation by regulatory authorities and potentially a criminal prosecution. So this is a really interesting piece, I suggest, because it's in part about what's happening in practice, but it's also about what legally could happen and what we think could happen in the future. So in practice, as Sarah's referenced, HSE really clearly say on their website that suicides aren't reportable under RIDDOR. I'm not convinced about that, actually, and Heather's probably going to ask some questions about that. But their rationale is that suicides are not work-related accidents. Clearly, suicide isn't an accident if we look at it factually, but whether or not it comes within that definition, I think, is the key piece. However, because these are deemed not to be RIDDOR reported, and therefore either they won't be reported or the HSE will ignore a RIDDOR report, lots of suicides connected with work are just not going to get on the HSE radar. What I do think, though, is really important is that it's understood that for the HSE or a local authority, for instance, to take an action, they don't have to have a causal connection between an actual death, in this case a suicide, and any failures by employers. So under the Health and Safety at Work Act, that the HSE could investigate whether there had been a breach by the employer of their duties to ensure, in this case, that the mental health of an employee at work. Or they could look at the management regs and say that there hadn't been a suitable, sufficient assessment of risk, and whether or not the failure to do that ultimately resulted in somebody taking their life is irrelevant. The HSE could, in law, take an action. In the most serious cases, and I suppose this is most similar, but it's a very different type of offence to that France Telecom one we heard about, there could be a corporate manslaughter investigation and prosecution against a company, or gross negligence manslaughter against, for instance, an individual director. But these cases are really hard to prove, in part because there has to be that causal connection that we talked about, and the failure has to be a really gross failure. It does really surprise me that we haven't seen any prosecutions by the HSE for inadequate management of mental health risk. That's what I would expect to have seen so far, and what certainly the lawyers have been talking about for the last few years, and particularly in those industries where we've seen the risk as high, construction, the NHS, as some of the examples. And we'll probably come on to questions to talk a little bit about this attitude of the HSE to suicide and stress risk, and whether that's going to change over the next few years. Next slide, please, Heather. So finally, on those three legal risk areas is a flag around civil claims. So these are private actions, not ones brought by a regulator on behalf of the state. They're private actions which will be brought either, in the case of suicide, by the estate of the deceased and or by their family. And what they would be doing is suing an employer in negligence. In the case of suicide, and in fact in the case of the precursor, the work-related stress, these cases are really difficult to prove because of what you have to prove to get home in negligence. And I've put on the slide there the areas that have to be proved. So firstly, it has to be established that there was a duty of care. That's not that difficult in an employer-employee relationship because there is one. Then it has to be proved that there's been a breach of that duty. Again, that may or may not be that difficult to prove depending on the facts. But then it has to be shown that the injury, or in this case, that the death was foreseeable by the employer, and that the failure by the employer has caused the death or had significant contribution. And that is where it's really difficult to successfully get there. In terms of damages, i.e. if a family was successfully going to bring a case, what that looks like, this could include for the estate an award related to pain and suffering, any pain and suffering that had happened pre-death. After that, there's what's called a fatal accident award, which is a notional sum related to a fatal injury. And if the deceased had left behind a dependent family, so children, a husband or wife, for instance, then there is an award for that. What we see as a result of this is often these cases aren't brought for the money. Maybe lots of personal injury cases aren't, but they are brought usually to have the issues aired, and possibly because we're not seeing the action by regulatory authorities, which is what a lot of families would like. Heather, if we can move on to the last slide. Thank you. So before handing back for some questions, I'm conscious that we've talked about the types of actions, but less about what the courts or the regulatory authorities expect to see from employers in terms of good standards to show that duties are being met. Heather touched upon this right at the beginning. I think the main flag that we're seeing, and we see in cases, even if they don't succeed all the way through, is that we've definitely moved away from a position where it would be accepted that if a company had in place some really kind of basic reactive approach, some kind of bland well-being program paired with employee assistance line and a mental health first aider, we're just seeing that now as not enough. What we're seeing instead is an expectation that an employer will have thought about mental health across their business, not just in response to an individual who's exhibiting a mental health condition, that there are organizational mental health risk assessments being carried out, which are driving a systems-based approach through the business, which as health and safety or HR professionals, you'll be quite familiar with that as a broader concept across all sorts of areas. We'd expect that the company would be thinking about either the HSE's management standards or ISO 45003 or some other kind of science-based, psychological-based standard in order to put in place a program. And companies should be able to show then how that risk is being minimized. That might be through policies and approaches, including in some of those key areas that Sarah's touched upon: workload management, bullying and harassment, trauma exposure, etc. So I think, Heather, handing back to you, that's probably aligns with lots of things that you deal with, that real proactive approach that, yes, it's not resulting at the moment in lots of legal action, but we're certainly seeing that discussion on that's the expectation to meet the legal duty.
Thank you both very, very much. We've got lots of questions come in, and I've also got some as well. And I'd actually like to, I've spotted lots of my friends who are experts on this call, and I've spotted that Claire Forshaw's here. And Claire, I know you can't speak for the HSE anymore. You used to be with HSL. I know that you're no longer with them, but I cannot tell you the number of health and safety professionals that I have spoken to who have a complete misunderstanding of the requirement to do a organizational stress risk assessment. A, they tell me it's guidance, it's not law. And B, they tell me they're doing them, but they're doing an individual stress risk assessment. Claire, could I just ask you to come off mute for me just for a moment and just reinforce this message that actually it is a legal requirement to do an organizational stress risk assessment, please?
Yeah, absolutely. Can you hear me?
Yeah, we can. Yeah.
Right. Yeah, I mean, within the Health and Safety at Work Act, it's always covered the need for assessment of psychological, psychosocial risk factors in the workplace. Often, absolutely, people judge that as being for when an individual becomes ill, and then we try to get them back to work, and we undertake a risk assessment for bringing them back to the workplace. But this is an organisational risk assessment. It is true that the HSE management standards are guidance, but like a lot of guidance, it's guidance in how to comply with the law. So it's, do it any other way if you like, but you must have a psychological risk assessment. And if the risk assessment says, like with any other risk assessment, we don't have a risk, or the risk is fairly low because we're managing it very well, that might be great. But I'm guessing in most organisations, there will be quite a few issues highlighted by an actual organisational risk assessment, and that will highlight issues that need management, that need improving. And hopefully that kind of preventative approach will start to highlight some of the workload factors, some of the bullying factors, some of the kind of general control issues that people have and experience, and then start to suffer from mental health effect from. So absolutely it does. And something I was interested there in terms of a health and safety approach to some of these issues. We do incident investigations for accidents at work and work-related deaths. I'm guessing most workplaces would not even consider doing an incident investigation for a work-related suicide. So, that might, again, bring okay, it's reactive, but it might bring a lot of learning into the workplace if we did a more kind of proactive investigation response to some of these issues as well.
Thank you so much, Claire. I'm sorry for putting you on the spot. I was too tempted. I saw you there, but thank you so much. So yes, Mel, we can certainly supply you a template of an organisational risk assessment. I can certainly put that into the slides when we send this around. So we will actually send around a recording. So you will get that in probably a week or so, depending on how much editing we need to do at the end of it. And by the way, I'm sorry about my mouse moving around. I was told it was distracting. I was trying to answer chat at the same time. Anyway, moving on. So I think this is probably for you, Sarah, this question. The first one that I had was, I think it's really interesting, this approach that is very different across the channel with, we had a discussion earlier where I said to you that in French bookshops, there is, yes, the personal stress section, which is as big as the UK personal stress section, but there is also shelves and shelves and shelves of content on stress at work and on psychosocial risk specifically, which is missing in the UK. Now, you could say that, okay, we're a very individualistic society. But then the US is also an individualistic society too, isn't it? Are there lessons that we can learn from the US where they are taking organizational stress risk potentially more seriously because suicide at work is investigated?
Yeah, well, I mean, I can't speak on work-related stress generally, but certainly in relation to work-related suicide, there are very clearly defined criteria used to identify a suicide as potentially work-related and hence requiring further investigation. And what I would say is I think those criteria are a model that could potentially be used in the UK. France similarly has a set of criteria that are used to identify a suicide as potentially work-related and requiring an investigation under a health and safety framework rather than, by the coroner, which happens in every case of suicide. And so in the case of the US, if a suicide takes place in the workplace, on the premises of the workplace, it is recorded as a work-related suicide. If there is material evidence of a definitive link to work, it is also treated as a work-related suicide. By material link, it can be a suicide letter. It can be the person taking their own life in a work vehicle, if they're wearing a work uniform at the time of their death, if they're using a firearm that they've obtained in the workplace, if they're using medication that they've obtained in the workplace. All of those are considered to be material evidence of a potential work-related suicide. But I think the important thing is that, they are counted and it's acknowledged as a public health risk, and therefore preventative measures are put in place in the workplace that arise from that. If you say that it doesn't exist and that it's not a risk, those preventative measures and those investigations don't follow from the recording.
I think this question's been asked as well, and I think it pertains to what you just said. But in other countries, then, where there is a requirement to report, it isn't only if the suicide takes place in the workplace. It could be at home, but but there is some other connection with the business,
So to give the example of France, it's if a suicide takes place in the workplace in France, it's presumed to be work-related unless proven otherwise. It's automatically investigated as a work-related suicide. If it takes place outside of the workplace, the family would then need to bring a case to the courts for it to be investigated as work-related. But if it takes place in the workplace, it's automatically investigated and treated as work-related, unless proven otherwise.
And the one case we had, sorry, Sarah, I'm not sure if this is for you or for Mary. I'll come to Mary if it's not. But the one case that we had in the UK, how did that get uncovered? And how did it basically get brought to court?
Do you want me to pick that up, Sarah?
Yes, yeah.
I don't know the actual answer, but I think there can probably only be one answer. So the case I think that we're talking about there is the Corby IBC Vehicles Limited. That was a civil action, so it would have come about by the estate or the family bringing a claim. The difference is that it was successful, whereas a lot of them haven't been. It might be helpful if I give you a few facts. I've got a few comments on some of those things. I think it is interesting. So I'll just read this. So the facts of that case was that there was a serious accident at work where a maintenance engineer for Vauxhall motor cars suffered severe head injuries, depression, and PTSD. What had happened was that a machine on the production line where he was working had malfunctioned. A robotic arm that was lifting up some panels on the press line had struck him on the right side of his head. Most of his ear was severed. He had several operations. And if he hadn't moved his head, he became aware after the event that he would have certainly been killed. It was 6 years later that he took his own life outside of work in a pretty awful way. And what happened, this case having been brought, is that the employer admitted that they had breached their duty of care to the employee. Obviously, there was an accident that had happened, but what they denied was the liability for the suicide 6 years later. And they argued that that employee hadn't had any mental health problems before the accident, and therefore they shouldn't be responsible for the suicide. And what the court found is that no, they were liable because his injuries, his psychological injuries, the PTSD and depression had all come out of the accident at work. So the issue was not whether the suicide was foreseeable. It was about whether, if you suffered that kind of accident, the depression and ultimately, therefore, sadly, suicide being the result was foreseeable. So when we talked earlier about how difficult it is to get through, you can see that type of very clear-cut evidence about something at work creating a mental health condition that ultimately led to suicide. And as we know, often these things are not seen to be that clear-cut. There will be other factors involved. But just touching upon two of the other things that have just been mentioned, I think it's really interesting. So RIDDOR says that the actual RIDDOR legislation itself says that you have to report for a number of reasons, including if there has been a work-related accident. And then if you look in the legislation to what does work-related accident mean, it says where the accident has been out of or in connection with work. So when we say in the UK that, or the HSE say that this is not reportable, that is the HSE's view, no doubt them having taken advice, possibly other factors. There's lots of ways we could argue about that as lawyers. We could say, well, it's not an accident. But to those points about reporting in France and the US as examples, this is quite similar, out of or in connection with work. So it could be something that's happened in work, or it's somehow connected to it. So I think you could layer a broader definition on it. But there is another reason in France why there might be more reporting, and there may be lots of other reasons, is when we look at that France Telecom case, it was brought under an offence in France called moral harassment, is the translation. And what that says is if there's evidence that there's been repeated acts which have as their object or effect a deterioration of an employee's working conditions, then there'll be an offence. And when you go into that, it says, so it could have infringed on their dignity, it could have altered their physical or mental health, or, and I can't even read my writing on the third one, there's another position. But what's important there is it's not about suicide, it's about the acts of an employer and an impact in terms of kind of mental health condition, or as we say, dignity. So I think that is potential in the UK as well to interpret that way, but I guess it's spelt out much more clearly in France. And no doubt, Sarah, you've got views about the cultural piece. Sorry, that's a lot of me talking, but I hope that's helpful.
No, that's great. And actually, we've had this raised in the chat as well, and I'm interested in both of your answers on this. So is it, as a health and safety or HR professional, if you see that your organisation, perhaps you've asked and you've tried to push the case, that actually really there is too much workload, or some of these risk factors are really present, or there's bullying, or you think that the conditions are such, and you're not being taken seriously by your senior management team, should you report that to HSE?
Well, I guess that is always a question for the employer at the end of the day. I think the problem is where that's going to land with the HSE. But I think that if there's a cultural and endemic problem being reported and the HSE look at that, I suspect there's going to be that's where we're going to see our first case, I think. We're going to see a case, hopefully never as extreme as that France Telecom, because no one ever wants that to happen again. But I suspect the first time the HSE will feel confident enough to bring a case, and I think they will bring a case, and someone's referenced their strategy, they're focusing on this, is where they say, not only is an employer not got a risk assessment, because let's face it, lots of people don't at the moment, but they're really just turning a blind eye, ignoring it, and there is clearly an endemic problem. So how that is going to come to light, but I do think the HSE have got this on their radar, and so therefore the inspection regime will probably change, and that's the type of scenario we're going to see play out.
Yeah, and there have been some enforcement notices recently issued for no stress risk assessment, haven't there? We know that that is something that they are starting to do. So no stress risk assessment in place. Sarah, did you want to say anything about that?
No, just I think the HSE has a sort of interesting position because it has become increasingly active on work-related stress. It does recognise work-related stress. But our point, we did, after we completed our report, we made a presentation to the Workplace Health Executive Committee, which advises the HSE. And one of the points we made to them is that, you know, you recognise work-related stress, but only when an employee is alive. If that employee, because of the effects of extreme work-related stress, takes his or her own life, it's considered to be subjective, voluntary, to be unconnected with work. So this sort of gap in their approach that recognizes work-related stress, recognizes stress as being something work-related, but always treats suicide as something unrelated to work, as something that stems from subjective circumstances. And we have had, you know, over the years, we have negotiated with the HSE. Their position is that suicide is too subjective, complex, and multifaceted to be considered as a work-related problem. We have said to them, well, you know, in other countries, in the United States and France, it is considered as work-related, not as subjective, complex, multifaceted. I will say they have, in November, for the very first time, the HSE included on its website suicide prevention guidelines. And that they introduced those after we presented to the Workplace Health Executive Committee in October. And this is a symbolic breakthrough because up until now, HSE has refused to see suicide as an issue connected in any way to work or the workplace. So there are now suicide prevention guidelines on the HSE website.
Thank you. I thought, by the way, that what was really interesting about the causes that you found were, and this sort of is borne out by a stress risk assessment that we did with an organisation there was an awful lot of traumatic events that those people were dealing with, and they assumed that the exposure to trauma would be their key stress risk factor, and it was not. In their case, it wasn't work overload; it was working arrangements, but it's really interesting that overload is the key reason. When we talk to people more widely and do stress risk assessments, we find that work overload is the key reason that people are struggling. Would you say, Sarah, that in France, this was also a big issue?
Yes, I mean, I think, you know, our workplaces are, you know, very much influenced by the global economy, and I think our experiences of work are similar. What differs is the legal and regulatory context for responding to them. And whereas, you know, France has a regulatory framework with which Mary went into for responding to work-related suicide, in the UK, there is no regulatory framework in place. And, you know, that's extremely problematic. But absolutely, unmanageable workload is an issue across the board, I think, and certainly was quite prevalent in the cases that I studied in France.
Okay. I don't know whether this is for you or for Mary, so I'm going to just go to whoever wants to answer it. But this question around life insurance, so insurance policies. So most employee liability, life insurance and death and services benefits do not pay out if the death is deemed suicide. Why do insurance companies take this stance?
Yeah, I mean, for my part, I don't know why insurance companies take that stance, and I suspect that some of it may be dated or linked to financial reasons, and we would have to look at, get someone else to answer that. But I think linked to that point, there was a piece around interest at inquest about the conclusion, used to be called the verdict of suicide. And I have certainly seen that, where you've either got an insurer listening carefully to that. Sometimes some coroners take the view that they don't like to use the word suicide as the conclusion, even though in lay terms, that's probably what we would define it. I think a lot of that is because of the negative connotation linked to the word. So I'm sorry, I don't know the answer about why insurers take that stance, but I think that is probably right. And it's probably a discussion with the industry, really, as to if there's any way to move that forward.
Sarah, did you know anything more than Mary on this one?
No, only that as part of our study, we talked to bereaved family members in each of the cases. And, there was a deep sense of injustice because, first of all, there was very strong material evidence that work-related factors were at play in the suicide of their loved one, and the fact that they weren't officially acknowledged or recognized was one issue of injustice, but also there was a sense that they had no recourse. In some of the cases that we looked at, they had engaged lawyers and solicitors to make a case against the company in order to be able to gain any type of financial compensation. My colleague Hilda Palmer knows an awful lot more about this because she was involved in some of the cases where they tried to secure financial compensation for family members who otherwise are left with nothing because it's not treated as a work-related incident.
Thank you. We've got about 3 minutes left, so I'm going to ask you to take 1.5 minutes each, please, if that's okay. And I'd like you to answer two things. One, how do you think the regulatory framework or the enforcement framework should change? And two, what can the people on this call who are HR and health and safety people do tomorrow morning, or not tomorrow because it's Saturday, but Monday morning, to try to ensure that this doesn't happen in their workplaces? Sarah, you're off mute, so I'm going to start with you.
Yeah, so I mean, our key demand is to count work-related suicides, to make suicide a reportable incident, to treat suicide as a potential health and safety issue rather than immediately presuming that it is a private individual decision. And that is our key ask. What people can do is to support the Hazards campaign, to keep up the pressure on the HSC to include suicide as a work-related death. Not recognizing a social problem doesn't make that problem disappear. It creates risks for other employees.
Thank you, Sarah. Mary, what about you?
Yeah, I'm not sure the regulatory framework necessarily needs to change, as I've said, but I do think the interpretation of it does. So I think the continued campaigning of the HSE and other is important. I think it probably will happen from government pressure in the end, because this is costing the UK economy so much money, and work can influence it. In terms of the ask for HR and health and safety professionals, I'd say two things. First of all, link up with each other. So is the health and safety and the HR professional in an organisation talking, because you've each got amazing strengths that you can support each other on that. And secondly, if you don't already have a systems-based approach looking at mental health in the organisation, I think that's the starting point. So it's probably about getting your board on board with that and taking it forward.
Thank you very, very much. I completely agree with those comments. HR and health and safety, you have experience in risk assessment. HR, you have a lot of the data here. So the two of you need to work hand in hand. And a systems-based approach. If your board likes standards, then look at ISO 45003. If you're compliance-led, then look at the fact that you're supposed to be doing an organisational stress risk assessment. So, you know, all of these, training is fantastic. However, let's look at a systemic approach to stress to prevent some of these potential suicides in the future. Thank you very, very, very much, Mary and Sarah. Absolutely brilliant, really insightful. We will be doing a recording of this. We will send it out to all of the people that attended, and you're welcome to distribute it as you see fit. Thank you very much. Have a lovely weekend, everybody. Thank you.
Thank you.
Thanks all.
Thanks.
Thanks.